Good afternoon, everybody. This is Eric Hauge, Executive Director of Homeline, and thank you for joining us today, Wednesday, May 20th at 1:30 p.m. for Homeline's, I think, fifth landlord-tenant COVID-19 pandemic-related webinar. We are going to get started in just a minute here as people join. Just a reminder, today's seminar will be led by Homeline's Managing Attorney, Mike Bra. And you can submit questions. We had folks submit some questions in advance. Mike's probably going to run through a quick overview of previous weeks, but then get to the questions, and feel free to, at any point, submit your questions about any of these topics via the question and answer Q&A box over Zoom, and we'll get to them, or through the chat, or if you want to raise your hand and we can call on you. Reminder, Homeline is a statewide Minnesota nonprofit organization, provides free legal advice for renters, and we've advised over 250,000 renter households since opening in 1992. We serve folks in 4 languages: English, Spanish, Somali, and Hmong. And we rely on our staff of housing attorneys, advocates, organizers, and many law student and community volunteers and interns. That's our hotline's contact information in different languages. And I'll jump back to that in a minute. I just want to point out again that we're going to continue to host these webinars for the foreseeable future, 2 of them each week at least, Wednesday for an audience of tenants and advocates and service providers, and on Thursday afternoons for an audience of landlords and managers, as we've continued to see pretty consistent attendance and a lot of important and helpful questions coming in. And all of the recordings are on our website. Actually, they are assembled all at the bottom link there, homelinemn.org/COVID. A little bit further down on that page is a list of all the recordings for both seminars. We did have a technical issue last week and didn't, unfortunately, weren't able to record last week's, but the rest of them are there. And with that, I am going to pass it over to Homeline's Managing Attorney, Mike Bra. Thank you.
Thanks, Eric. And as Eric mentioned, we do have some questions built up, 4 or 5 questions that have been sent in advance. And somebody has already submitted a question to the Zoom panel as well. But we should have plenty of time today to answer your questions. So if you've been holding back, waiting to ask a question and didn't think you'd be able to have it answered, today's a great day to try to get your question in. We still have somewhere between 35 and 40 people watching at this point. So I'll answer the Zoom question that we got first, which is, how many weeks do we plan on doing these calls? As long as people want to remain informed. We are still in this new time, the COVID-19 era, of laws moving around on a fairly regular basis. And I'll be talking about the biggest change within the last week in a second. But what we're trying to do with these Wednesday sessions, along with our Thursday sessions where we talk to landlords and property managers, is to keep people as informed as we can. I mean, this is a lot of unusual things happening on a fairly regular basis. What the courts are doing, what the governor's doing, what the state legislature is doing, what cities might be doing, and so we're trying to stay as informed as we can and share that information with as many people as we can. And as long as people keep wanting this information, we'll keep doing it. We seem to have some core group of regulars for each session, and that's fine. But we also seem to have new people every week, some of whom have never heard probably what we're talking about, and others who maybe have seen the recorded version or whatever. But we're trying to keep this as current as possible, and we'll stop doing it when it's no longer needed, frankly. So as long as people keep tuning in, we'll continue to provide this free service. So I mentioned there was a change last week. The last time we had a session was last Wednesday, and the governor had not yet announced the extension of the peacetime emergency declaration, which is What the eviction moratorium, the state eviction moratorium, is tied to in time is the declaration of the peacetime emergency. Now, this is one of those things that is actually very confusing. We get a lot of calls on our tenant hotline where we take 15,000 calls a year roughly, or emailed to us saying, wait a second, the governor's, the knobs and the dials on the governor's chart, things are opening. So is it legal for a landlord to go file an eviction yet? I can't really understand what a landlord could do as far as evictions go based on the governor's shelter in place or recommended shelter in place situation that we're in currently. And the short answer to that is the shelter in place is not affecting the eviction moratorium set up by the governor. So again, I don't like to cite a lot of statutes in this session or any of these sessions. I want to keep this as sort of understandable as possible, but the governor's executive order 20, like 2020-14 remains the eviction moratorium state law during the COVID-19 epidemic. That is tied to the declaration of a peacetime emergency, which is not the same as the shelter in place orders. So anyhow, what the governor did last week with the extension of the peacetime emergency declaration is, since the eviction moratorium is tied to that, the peacetime declaration was extended through June 12th. These are being done on 30-day increments, which is, if you've been watching over the months, it's not always the same day of the month that this change occurs, because some months have 31 days, some months have 30 days, and so it gets a little bit confusing. But June 12th is when the next peacetime emergency will lapse. Now, at that point, the governor could extend the peacetime emergency more. We're interpreting rules that I don't think have ever been interpreted before, but our understanding of it is that the governor could unilaterally extend it again. The House and the Senate, the State House and the State Senate, could end the peacetime emergency declaration, but both chambers would have to vote to do this. The other new thing about the peacetime declaration is if the governor decides to extend it once again, it will be during a time when the state legislature is not in session. And at that point, the governor has to call a special session, if for no other reason than for the State House and Senate to be able to debate the peacetime emergency declaration and decide if they want to both decide, again, the state and the House, both, Senate and the House, both to decide to end the peacetime declaration. So this gets a little bit complicated quickly, but again, we're trying to distill it to the things that matter today. Once again, we are on May 20th, just checking my calendar, May 20th of 2020. And we are still in a peacetime emergency, which means that a landlord still cannot file an eviction for non-payment of rent. A landlord still cannot file an eviction for having a boyfriend or a girlfriend move in with somebody, or for having a dog when they're not supposed to, or pretty much any other breach of their lease. The only reasons a landlord is allowed to file an eviction currently would be for a violation of a statute that says no illegal drugs, no illegal guns, no prostitution, no stolen property in the rental unit, or if the tenant is endangering somebody else in the building, or something like that. It takes something to that level for a landlord to be able to file an eviction legally today. As mentioned before, the Attorney General's office is the entity tasked with enforcing these rules, and they have, over the weeks since COVID-19 broke out and these rules were declared, actually gone after some landlords that have tried to remove tenants, sometimes through lockouts where the landlord changes the locks or turns off the utilities, or just tries to throw things outside and say, get out. And so the Attorney General's office has the power to enforce that. It's actually a misdemeanor. So up to $1,000 for a violation, up to 90 days in jail for a violation as well. So there are some teeth built into this peacetime declaration eviction moratorium. That, again, is not the only question when it comes to an eviction, although it's sort of if we're thinking from a landlord's perspective, can I file an eviction today or not? The first hurdle they have to get past is, does the state allow me to file an eviction currently? And in most cases today it does not. But once again, if we fast forward in time to June 13th, well, actually we'll say June 15th, the 12th is a Friday, so nobody's going to be filing an eviction at the courthouse on the 13th, which is a Saturday. So June 15th, the landlord goes to file an eviction. Can they do that if the governor does not extend the peacetime emergency? And the CARES Act, here's another layer that we have to get past from the landlord's perspective, is a federal law that does a lot of different things. But what it does as far as landlord-tenant issues go is the landlord is not allowed to file an eviction for non-payment of rent, just for non-payment. So here, if it's just the CARES Act analysis that we're doing, a landlord can file an eviction for an unauthorized occupant or a dog or any other breach of the lease. But for non-payment of rent, which constitutes well over 90% of the evictions in Minnesota every year, the landlord could not file if the CARES Act matters. So does the CARES Act matter? Our best guess is about 20 to 50% of households, rental households in Minnesota would be covered by the CARES Act. So any kind of subsidy, any official government subsidy, federally based, would automatically fall under the protection of the CARES Act, including something like a Section 8 voucher. The more complicated question is a single family home or a duplex or a triplex, a small place like that might have a mortgage that's federally backed by what we call Freddie Mae or Fannie Mae or Freddie Mac. Wow, I can never remember which way to phrase this. If we have a federally backed mortgage, then the CARES Act applies to those as well. And so a landlord wanting to file an eviction, the governor saying we're not going to do that anymore, we don't have a moratorium on evictions anymore, isn't the last question to ask when it comes to an eviction later on this summer if the governor does at some point back away from the eviction moratorium. But the fact that the governor extended the eviction moratorium for another month to June 12th means, in my mind, two main things from a tenant's perspective. Number one, the landlord still can't file an eviction for most reasons. And number two, the landlord, if the landlord is given a notice to vacate, where they ask the tenant to vacate by the end of May, for instance, a non-renewal, a notice to quit, a notice to vacate, these go by a lot of different names, then the moratorium on evictions also stops a landlord from terminating tenancies. So a notice to terminate the tenancy that was directed towards the end of May is not going to be valid. It's not going to be enforceable in a court from any meaningful standpoint. So anyhow, those are the two main changes that we have from what we knew at this time last week on Wednesday. The governor didn't announce all of this until 6 p.m. that night. And I'll be honest with you, our office wasn't sure. So I'm sure that there were a lot of places that had no idea what the governor was going to do with both the shelter in place and the peacetime emergency. But now we at least know where the peacetime emergency is scheduled for versus where it was last week. That being said, I've gone almost 15 minutes of me just talking nonstop. So let's hear the first submitted question, if we could, Eric.
Yeah, the first question submitted in advance. My landlord insists that it is legal for a notice to terminate the lease during the peacetime emergency and wants me out. Now what?
Right, so can't tell from that question when the landlord is asking the tenant to go. As I just mentioned, a notice to vacate for a time ending during the peacetime emergency clearly is violating the governor's order. No question about that. And I think it's, if a landlord tries to actually enforce it, honestly, I think by giving the notice to vacate during the peacetime emergency, the landlord has violated the governor's order. But there's no question, and the Attorney General's office backs us up on this part, if a landlord is trying to enforce a notice to vacate or a termination of the tenancy during the peacetime emergency. So on May 31, if the tenant doesn't go, on June 1, the landlord comes over and says, you got to leave. I got somebody else that's supposed to move in here. The current tenant says, well, I'm not going to go. What are the landlord's options at that point? Well, not much legally. They can't go file an eviction, not for this. I mean, they can try to file one, but I think it's violating the statute. The court will probably let them file it, but they won't schedule it, at least right now. And I think they have violated the statute if they actually file the case. So they can't do that. They can't simply throw the current tenant's things out. So there's not much a landlord can do to enforce that at this point. The harder question remains, what if the tenant is given a notice to vacate for the end of June at this point? Again, the peacetime declaration emergency ends June 12th. So if a landlord gives a notice now, or they gave one at the end of April for the end of June, some leases have a 60-day notice requirement. Is that going to be enforceable? At some point, a landlord is going to give a notice to vacate for the month following the end of the peacetime emergency, but they gave the notice during the peacetime emergency. And our view is that that's violating the governor's executive order banning tenancy terminations. But we haven't seen that case litigated yet because honestly, courts are closed and the Attorney General's office hasn't actively gone after those types of cases because they have so many of these other cases where landlords are trying to remove tenants on their own, sometimes without court involvement at all.
We got sort of a related question in the chat while you were answering that.
Okay.
If a tenant's at the end of their lease, maybe at the end of this month or something like that during the pandemic, and the tenant doesn't want to intend to renew, and the tenant doesn't intend to renew, do they go month to month?
So that question has I'm not sure if you all can see the question, but it's got a "we" in there. I think this is a tenant asking the question, so I'm going to answer it from that perspective. So the lease ends the end of May, and the landlord, I assume, has given the tenant a renewal offer where they can, renew the year or renew their lease for a year. Now, some landlords only want 1 year to 1 year leases. That's all they ever want. They don't want to do anything else, which is normally legal. But here in this situation, the tenant could say, you know what, I don't want to have a 1 year lease. I want to have, just enough time to figure out what I'm doing next. And so if they stick around past the end of May and they're still there and they pay their rent and the landlord accepts it, what's formed almost certainly under the law is probably a month-to-month lease, maybe with a 2-month notice requirement, depending on how the original lease was written. All the original terms of the lease remain in effect, except the fact that it becomes a holdover tenancy. And at present, the landlord couldn't evict the tenant for that reason. They simply wouldn't be able to because that's not on our list of reasons why a landlord can file an eviction during the peacetime emergency. So not renewing tenant right now, from a landlord's perspective, not really allowed if it's ending during the peacetime emergency.
All right. You answered this one already, but just to confirm, is there a set ending date on the eviction moratorium?
Yeah, it's actually a fair question, and I don't mind answering it more than one time or talking about it more than one time, because the peacetime emergency has lapsed twice already, right? I mean, we've run up to the deadline, and then the governor decides at the last minute to renew the peacetime emergency. And so our advice remains the same. We have to tell tenants, and if we were telling a landlord, we'd say, look, as near as we know, it ends on June 12th. But the governor could extend it. And I'm not sure if there's anybody the governor's office is talking to that's actually disclosing what they will do with any kind of certainty. And I think there's a couple of reasons for that. Number one, the law requires 30-day renewals. It's not like the governor, I think, if I read the rules right, can just say, I'm going to just make it a peacetime emergency through December. I've decided to go through the end of the calendar year. I don't think under the law the governor can do that. I think they have to declare it every 30 days. There's some legitimate arguments for the governor to wait until the last minute as well. They want to see what the information is on the ground, right? I mean, this is what we've been hearing all through the news at the national, state, local levels, is we want to make the best decisions we can with the latest information, the latest technology, the latest statistics. And there's no way the governor can do that until they wait until the last minute to decide this. So at present, the peacetime declaration, or emergency declaration, ends on June 12th. Will it be renewed? I really don't know. I don't know. Maybe it will be, maybe it won't be. I'm guessing it'll depend a lot on how things are going in the state while we're all dealing with COVID-19. Are the numbers ramping up? Are the numbers slowing down, or even better, disappearing completely? Then the governor is going to have to make a decision based on that information then. But at present, it's June 12th is when the peacetime emergency is over.
The next question, I'm not sure is specific to the pandemic, but what are a renter's right if a landlord refuses to pay back their deposit?
Well, okay. Yeah, I agree, Eric, that this is normally not what I would call a COVID-19 question, except for one main fact, which is the number one remedy tenants have available to them if they're going to dispute a security deposit is to go to conciliation court. We've been talking about evictions not being open to landlords right now, but conciliation court, small claims court, and many other courts throughout the state are effectively not open still. They're starting to open them up in pieces, and it depends on the county or the district that you're in. For instance, in Hennepin County, we're starting to see some tenant-related issues like rent escrows are starting to happen on a slow level. Things that were filed before COVID-19 was declared are starting to be scheduled now. But will conciliation court open up? When I'm sure they will, but when it'll happen is an unknown at present. We are hoping it'll happen soon. But so if a tenant has a dispute with a landlord about a security deposit, then the normal remedy is, like I said, to go to small claims court, conciliation court. Tenants can still send a letter disputing what a landlord is doing with a security deposit. This is the prime security deposit dispute season. Because this is when tenants move in and move out, right? We've talked about this in past weeks. Most leases end in the summertime or spring or fall, late spring or early fall, because everybody wants it that way. The landlord wants it that way because it's easier to re-rent. The tenant wants it that way because it's a lot easier to move at the end of June. That can be pleasant versus the end of January or the end of February. So this is when we see leases end. And this is when we see the majority of the disputes about security deposits throughout the years during these warm weather months. So we're going to hear more and more questions about this. If a landlord is keeping a deposit, a tenant thinks it's unfair, typically one of the first responses from the tenant is to say, wait a second, I don't agree with what you've done. Here's why I think you're wrong. Or, wow, you just gave me some really vague information here in your security deposit disposition letter, which is what the landlord is supposed to send within 21 days of the tenant moving out and giving a forwarding address. So a tenant can dispute this in writing in an email or a text. I'd prefer an email or a letter. If a landlord says no, then conciliation court really is where these things end up. And they cost about $70 to file. If a tenant's income is low enough, they don't have to pay anything. They qualify for a fee waiver to file the case. And in general, cases are heard 3 to 8 weeks later. Now, another concern about conciliation court is when it opens, I have no idea how quickly cases will be scheduled, because I assume that there have been people holding off on filing cases at the conciliation court level, just like at every level of the court world. And so my hunch is there will be a rush of cases, and so scheduling will be much further into the future than it is currently or was pre-COVID-19. So a tenant's number one way to dispute a security deposit dispute is not available presently, not really, not meaningfully. And it will be eventually. So like I said, it can be the back and forth, the negotiating with the landlord, or telling the landlord, hey, look, I'm going to take you to court as soon as I can. Sometimes that'll convince the landlord to respond and have a meaningful negotiation with the tenant before it does end up in court. But if not, then they can't file. Like a lot of the types of issues that we're talking about, I don't mind giving sort of generalized advice in this setting. That's fine. But we would certainly want tenants to contact us. We talk to well over 1,000 people every year, renters, on the security deposit issue alone. And so we understand sort of the nuances of security deposits, and there are a lot of nuances, and every case has its own specific issues that come up. And so, like I said, having generalized advice is great, but specific advice matters a lot when it comes to something like security deposit. And so please feel free to contact our free tenant hotline or use the email and attorney service, which is also free.
Next advanced question. Tenant's lease states the landlord can charge 8% late fee. If the tenant didn't pay in full May rent, when June comes, can the landlord charge the total on the total unpaid balance, including late fee, or only the current rent amount?
Okay. So the first part of this answer is that the CARES Act, once again, we have that question, does the CARES Act matter? If the CARES Act is an issue here, so again, if we have any kind of federal subsidy or if the mortgage for the owner is federally backed, then late fees are not allowed right now. So there's no late fees if the CARES Act is in play. As I mentioned at the beginning, 20 to 50% of Minnesota rentals are best guess. The CARES Act covers, but that means 50 to 80% aren't covered. And in the state setting, there is no ban. The governor's orders don't stop late fees from being incurred. There were legislative proposals, both in the Senate and the House, that both had the late fees removed, where a landlord could not charge late fees, but those did not pass, so they are not the law. I know that a place called the Minnesota Multi-Housing Association, which is a landlord trade group, very early in the COVID-19 declaration, so this is mid-March of this year, sent out a press release where they talked about certain things that shouldn't happen. And this was before the governor had issued a moratorium. And they said that evictions shouldn't be fileable until at least May 31. And they also said that landlords should hold off on late fees. So, and I can tell you from talking to over 1,000 tenants, I'm not even sure how many tenants we've advised on COVID-19 issues so far since it started. But many landlords are foregoing late fees right now. If they're getting full rent, they're pretty much going to be content with that. And if not, they'll work out some sort of payment agreement with the tenant, because landlords are rightly concerned that some tenants might not pay anything. And so agreeing to waive a late fee might convince a tenant that is thinking, well, look, I owe 1,000 plus it's another $80. I don't have the $80, so why should I even bother paying the 1,000? Most landlords in that setting right now are going to prefer to get the $1,000 versus $1,080 sometime if the tenant decides to ever pay. So waiving the late fees is done very frequently right now. I would say more often than not by landlords in Minnesota. Again, under the CARES Act, they have to waive the late fees, but in every other setting they don't. But still, we're seeing landlords waiving the late fees, partly because I think it's a good business move. Like I just mentioned, you're more likely to get the full rent from the tenant if you're the landlord, but also partly because I think landlords, just like all of us, understand that most of their clients, the tenants, certainly didn't ask for this either. It's not like they just decided to stop going to work and so they aren't getting paid. They just aren't getting paid because there's no work available. And so landlords are people too, and they're trying to figure out what's a fair way to go forward. And shaving the late fees off is seen as a way to be, somewhat magnanimous, which is something landlords sometimes aspire to. They don't always hit the mark from the tenant's perspective, but yeah, we've seen a lot of landlords waive the late fees.
All right, last question in advance, and you've answered this to a certain extent, but just based on the way the question is
Yeah.
posed, you might have some more to add. I'm wondering about the rent moratorium. Any idea when it will be over and how that would look?
So I assume that they're talking about the eviction moratorium, or do you think?
Yeah, I think so, but be clear that it's not a rent moratorium.
Right. So yeah, since I think we've talked about the eviction moratorium several times already, I'll talk about the concept of a rent strike or a rent moratorium, which is something that was talked about a lot more, I think, at the beginning of the COVID-19 pandemic, and it's subsided somewhat since then. But it might flare up again when June rolls around because more rent is going to be due. And one of the reasons why I think the rent strike conversations stopped happening as much as they were at the beginning is, first of all, the governor's order, the eviction moratorium, says very clearly that rent is due, as does the CARES Act. The rent is still due. It just limits the remedies the landlord has against the tenant if they don't pay their rent on time. The other thing that I think has put a damper on the rent strike or rent moratorium concept is that tenants, and people in general, were receiving more money through unemployment insurance, along with the federal stimulus assistance that they weren't sure was ever going to happen when the COVID-19 first began. The rent strike sort of momentum was I think probably at its strongest, and I was hearing it the most certainly from mid-March to very early April. But then we didn't get as many questions about it or calls about it at that point going forward. And so I'm thinking that some of the the pressure was alleviated by the fact that money was coming in that people had been told they were going to get, but until it was in their pocket or in their bank account, they weren't sure. Once they got it, then they started realizing, okay, I can hopefully pay what I need to pay to keep my housing in place. But as this COVID-19 sort of era continues on, and jobs aren't coming back quite like they had before, which is going to be the case in many industries, sadly. The notion of a rent moratorium or rent strike is probably likely to resurface. But again, what we've been telling people since this all began is there's nothing in the law anywhere that says you get to withhold your rent, go on rent strike, or cancel the rent is another phrase that we'll see. All that's happened is the remedies available to the landlord have been put on hold. They are paused. The rent is not wiped out. It's not eliminated. I can certainly envision legislation like that, but it hasn't happened, and I haven't seen it meaningfully considered at any level where it has any sort of chance at passing. I've seen it suggested by several legislators, but the sheer volume of legislators you'd need to get something like that passed, I haven't seen that at any level yet. And so counting on that, I think, is really unlikely. I'm not sure if that's the direction that somebody meant to go in, but if not, it was probably just about evictions, and we'd answered that earlier. But
Yeah. All right. So we're going to take some of the open questions that have been submitted over the Q&A now. And if you have more questions, feel free to add to them. Anonymous asks, what happens if my landlord takes the possession of my apartment early with a promise to pay the rent back to avoid potential loss of next tenant and later refuses to pay? And I asked the landlord to pay it back. I was supposed to vacate on the 31st, but landlord requested to vacate on the 5th. Landlord moved tenants' items out since I was out of state, now refuses to pay the rent and the deposit, also asking for additional amount for moving and holding the items from the 5th to the 20th.
okay. You're all getting a glimpse into sort of what we might get emailed to us on an email, an attorney directly question, or a phone call on our tenant hotline. And what I can tell you about this question is there's a lot of nuance and detail to it. But there's honestly more information we'd need to be able to give a useful answer to that one person. So I'd strongly recommend that you contact our tenant hotline, and Eric will make sure that those numbers are up on the board, either at the end or again in a second, however he wants to do this, or email the attorney directly. And the reason why is there's going to be questions that we need to interact with this person on to be able to try to figure this out. But I will say a couple general answers here to what I see. The first one is that if the landlord asked the tenant to move early because a new tenant was coming in, and then the new tenant fell through or got there later or something like that, which occasionally happens, the current or first tenant's argument is going to be bolstered substantially by proof of what was agreed to. Proof of what the landlord asked, proof of what the first tenant had agreed to do, and in exchange for what. So whether there's text, there's emails, going back and forth, we'd want to see those sorts of things to try to figure out, hey, what was the modified deal? Which is exactly what a judge would ask or should ask if this is in a conciliation court setting, which is where these kinds of cases traditionally end up. As far as the property goes, there's a 28-day rule, and today's the 20th. I would, if there's property you want to recover, I would insist on getting the property back in writing. I believe on our website we have a form letter for property recovery, which is something we haven't dealt with a lot in the COVID-19 month and a half that we've been dealing with. But that's still a law that exists in Minnesota and has for a long time. The landlord is supposed to hold on to the property for 28 days. However, the tenant has to demand it back in writing during those 28 days and say when they're going to swing by to get their property. Now, it doesn't have to be the tenant themselves. You can send a friend or a family member over to get the property, but you do have to state when the property will be picked up. And if it's not done within the 28 days, then the tenant's rights are whittled substantially when it comes to property. And as far as disputing this, so there are terrible things, and I don't need to list them, about the COVID-19 epidemic. there is one tiny sliver of landlord-tenant law world that is slightly better for tenants, arguably in the post-COVID-19 world, certainly in the right after post-COVID-19 world, and that's this. A tenant that is disputing something and wants to go to conciliation court with a landlord, a former landlord. Normally, when they've moved to another state, and this is something we deal with fairly regularly because people leave and that's when they want to get their deposit back and that's when the landlord keeps it and they want to sue the landlord, but they moved to Tennessee or Colorado or California. And it's easy to file a case from afar. You can file it from pretty much anywhere you can get something notarized. It's difficult to have the appearance set in court, though. How conciliation court has always been constructed is they want people to show up. These are very brief hearings, they're 5 or 10 minutes, and they look at whatever evidence people have, and then the judge sort of looks at everybody's face while they're telling their version of the stories and tries to decide who's being honest, who the truthful person is, and they try to, you know, base their decision, at least in some cases, primarily on that. I've told people for years that small claims court is very similar to the court TV shows you've seen on for years, right? The Judge Judy's, the People's Courts of the world. There's several very similar things. First, they happen fast. Like I said, 5 to 10 minutes. If you watch the Judge Judy show, usually they have 2 or 3 cases in a half an hour and commercials, a lot of commercials. So they happen quickly. You don't cross-examine the other side. You're not really playing lawyer. You don't object. You talk simply to the judge. They talk to you, and then the judge talks to the other side. You don't actually interact with the other party in a case. If you have evidence, you bring it, right? And you try to make the best argument you can. And the thing that's better for tenants out of state in the COVID-19 era is when conciliation court resumes, we can almost be guaranteed they're going to be phone or Zoom only cases at the beginning, which as I understand it is how rent escrows that are starting to begin again in Hennepin County are being set up, Zoom or phone in only. And so in conciliation court, if it's Zoom calls, and all the cases are Zoom calls, the judge isn't going to care that you're out of state. You can still sue from pretty much anywhere. So that makes it slightly easier. The old rule was the court had discretion to hear a case over the phone, and Zoom wasn't even an allowed approach. Courts are scrambling, trying to figure out how to make, you know, fair, meaningful court cases go forward now. And so they've been adopting the modern approach, which is using Zoom. And so I think suing from out of state, at least immediately after this hearing, is likely to be easier. And I'm not sure, sort of projecting out into the future, that won't still be an option for parties going forward, that they're allowed to appear in a Zoom setting or whatever they call it in 2 years. That might still be something that is done because the courts are going to realize that it's doable to do cases where not everybody has to go to the courthouse itself. And especially in metro areas, getting to courthouses and finding parking or finding the right bus pass, and what do you do with the kids when you go to court? We might discover as a court society that we don't need as many in-person hearings as we used to think we needed. Honestly, the reason that courts have been in person is because, well, they've been in person for 1,000 years. So that's how it's always been done. That's how it's going to be done in the future. Now we're forced to experiment with a non-in-person approach, and hopefully courts will get the kinks worked out really quickly and discover that, hey, maybe we don't need everybody showing up for all these court hearings. And maybe there's a more effective, more efficient way to go about doing this. So anyhow, ideally, that person, the anonymous person who submitted that question, hopefully they'll contact, again, it's a free tenant hotline or emailing the attorney. We have attorneys on staff, which means that any call to our office is anonymous for the rest of the world. We'll ask you what your name is, but it's confidential. I'm an attorney, and the attorneys in our office and every staff member that works there are bound by attorney-client confidentiality. So if there's some concern about sharing information, I can guarantee you we can't disclose this information to anybody else. So like a doctor or a religious official, attorneys are bound to confidentiality. So hopefully that will free you up to contact us directly.
And the number and address, email, link to the email form is up on the chat. Next question, what if my lease is up and my landlord doesn't want to renew, can they get me to leave?
My lease is up. I'm sorry, you removed the question before Saw the whole thing. Can you read it again, or is it gone?
Just if what if my lease is up and the landlord doesn't want to renew it? Can they get me to leave? So
Yeah,
no.
again, this depends on when they're trying to get the tenant to go, right? If the landlord wanted a tenant to go by May 31st and the tenant doesn't go, right now there's not much of anything in the world the landlord can do to remove that tenant, not legally, on June 1st if the tenant doesn't go. I guess the landlord could come over and say, I really wanted you to go. Here's $1,000. If you leave, I'll give you $1,000. I mean, they can always try to work out a deal, a cash for keys sort of negotiation. That's a way for a landlord to get somebody to move. And if the tenant says no to 1,000, the landlord might say 2,000. It depends on how much the landlord really wants the tenant to go. But can they force the tenant to go in their normal approach, which would be to go file an eviction for holding over? If the landlord gave a properly timed written notice to vacate for the end of May, and the tenant is still there on June 1, the normal remedy for the landlord is to go file an eviction for what we call holding over. Right now, that's not available to the landlord because of the governor's declaration. So, but if the notice to vacate was for the end of June, that's a tougher question. It depends whether the peacetime emergency gets extended again. And if it does, then that notice is clearly wiped out. But if it doesn't, again, I'd still argue that that notice that the landlord gave during the peacetime emergency violated the governor's order, but we haven't seen the case litigated yet.
The next question, is Minnesota doing everything it can do to get grants, money from the feds, CDBG, and FEMA for disaster and emergency relief, for rent relief specifically? How can Homeline help with that, maximizing that somehow?
I'm leaving that one for you, Eric. That's more your world than mine.
Yeah. I'm not sure I have an answer. There was a large package as part of the CARES Act that is in the process of going out, and that's to a certain extent what a number of the counties are using their CDBG additional COVID-related CARES Act funding for emergency assistance type and rental assistance programs. And so we have from the beginning recommended and made suggestions, based on what we're hearing from our clients and the extreme need for rental assistance, that funding like that go towards renters' needs. And so some of them have done that. I think Hennepin is we in the past couple of weeks, I think we've sent out the link for Hennepin. I think Ramsey is setting theirs up, and there may be others. Termination of lease provision is made for situations that are not within the control of the tenant, such as loss of job. Does COVID fall into a situation not within the control of the tenant?
I'm sorry, is that in the chat or is that in the?
That's the second one in the open question.
Oh, right. I'm sorry, just following along. So they're asking, does the tenant need to be COVID-19 affected to?
Well, it sounds like maybe there's a lease. If you can maybe send in a clarification, maybe there's somebody with a lease that has a termination of lease provision. So maybe it's asking, can I just terminate? Can I just get out of my lease early? Because
tell you what, let's ask that anonymous questioner to add a clarification. Leave the question up there. We'll go to the next question and we'll get back to it. The one from Linda about get it in writing, where I guess she didn't like that word magnanimous. When all these magnanimous landlords make verbal agreements for COVID, can tenants demand a written proof of the agreement? Okay. So Linda, my view on landlords is the same as it's always been. And I've done this for a long time, since 1996. In my view, most landlords are decent folks. I think 95% of landlords are trying to make a living and provide a service that's necessary. 5% of landlords are terrible, right? They just are. Bad people or bad landlords or both. And that's probably the reason why my job exists and why Homeline exists and why places like Legal Aid do this kind of work as well, is because there are those 5% of landlords that are out there that are either not good at it, they're inept, or they're just kind of bad folks. But we have seen many landlords that have been, as I mentioned earlier, willing to try to work with tenants since this all began For instance, on April 1, a couple of the largest landlords in the States sent out blanket notices to all their tenants, not knowing, honestly, whether or not they were going to get paid their rent for April or not. I mean, this was a really, from a landlord perspective, and I know it was from a tenant perspective too, from a landlord perspective, April 1 was a great uncertain moment in, landlord tenant history for them. They didn't know if anybody was going to pay. They weren't really sure. I had spoken with landlords as the run up to April 1, and they were wondering, because all these rent strike articles were appearing all over the internet in various locations, usually New York or Europe or wherever, and they were just wondering what was going to happen on April 1. And so we saw several landlords send out, as near as I could tell, unsolicited from their tenants, agreements in writing saying, hey, look, we realize that you might not be able to pay all your rent, and let us know what you can pay, when you can pay, and if we approve of your payment solution, whether it's not going to be paying everything at once, or you can pay 800 of your 1,000 right now, and we'll keep doing that until the COVID-19 era is gone. But then they'd agree to waive the late fees built into the agreement if it was agreed upon by both sides. Payment plans, in general, I mean, we don't have some sort of template that we have created that we really rely on, and there's one main reason for that is landlords simply don't trust them. I could write one that I think would be great for landlords and great for tenants, but virtually every landlord will look at it and see, oh, Homeline created this, probably favors tenants. Just like Homeline could create a lease. I could, spend the next couple days and I could sit down and write a lease that I thought was the fairest lease in the land. Knowing what I know about landlord-tenant law, I'd run it through all the other attorneys in the office, and we'd tweak it and make sure it's perfect. And then we'd present it to tenants to show to their landlord saying, hey, look, Homeline made this great fair lease. And the landlord would say almost invariably, yeah, I don't want to use that. Homeline's pro-tenant. I'm a landlord, so this is going to be favoring tenants, I'm sure of it. And they'll have the same view of a payment plan. So what I have done and what our office has done forever is if a tenant wants us to review a lease to see if there's a part of the lease they think is unfair, or just in general, hey, is this lease fair? I mean, I told a tenant yesterday that had sent me a lease and asked me a general question. Should I sign this lease? I'm a little bit nervous about several things in it. And she pointed out the things that made her nervous. And I looked over the lease, and I don't know how many leases I've seen in my life. Thousands, I'm sure. And I wrote her back and I said, you know what? I know that you want this place. Otherwise, you wouldn't be this far down the path. But this lease should scare you. This lease has stuff in it that I don't see in leases. I'm nervous about this from a tenant perspective because there's parts of it that the law is going to step in and help you on, but there's other parts that it won't. And so we look at leases, and we also look at payment plan agreements. And so again, landlords aren't really going to buy our payment plan agreement. They're just not going to like it because it comes from us. But we are happy to review one before a tenant signs it. So if a tenant says, the landlord put this payment plan in front of me, I just want to make sure I'm not doing anything I shouldn't do, we'll read it case by case and say, yep, we're okay with this, or wow, that part looks a little bit sketchy. I think I'd ask the landlord to change or tweak this. And unlike a lease, these payment plans, since they're so kind of hastily created, the landlord is much more likely to modify them based on a tenant request. Oh, what did you wanted to change part 2 of that? Yeah, okay, I guess I see your point. Yeah, we can change it. They might do that. And so instead of a blanket, here's the form to use, we need to look at the forms that landlords are putting in front of tenants. Or we can certainly talk to tenants about the ingredients that are necessary for the payment plan, which are basically, you identify the parties, you identify the original lease by date and by amount due and by the address. And then you say what the modified version of the payments are going forward, what's going to be paid and when. That's what a payment plan generally looks like. And so anyhow, that's the preferred way for landlords to do it. And so since landlords are the ones that are going to say no to anyone that we'd create, that's how it would work best.
So, we got a lot more clarification on this previous
Okay.
question. So it looks like they're giving us the actual language that's in their lease. And their question is, can I terminate the lease since COVID is not under my control and I am moving to a different state for shelter in place? And the lease provision apparently says termination of lease upon the request of the tenant. a provision is being made to allow either the tenant or the landlord to cancel the lease upon 1 month's written notice to either party. This provision is made for situations that are not within the control of the tenant, such as loss of job. Proof of reason for move may be requested.
Huh. Well, okay. And that's probably a little, I don't know. Can everybody see the Q&A, Eric, or is it just us?
Yeah, everybody should be able to.
If they wish to. Okay. Because this is a hard thing to follow with people just saying it. So if you wanted to follow along on this question, you should open up the Q&A, which is at the bottom of your screen, I assume. That's where it is on mine. So this is an unusual lease term, a very unusual lease term, where, as near as I can tell based on what I see here, the tenant is allowed to unilaterally end the lease provided there was a job loss. I've seen lease terms like this, but typically there is a penalty portion or clause built into the lease where the tenant has to pay a 1-month penalty or something like that if they want to break their lease early. I'd be surprised if that doesn't show up in this lease somewhere else. And again, I'd be happy to look at the entire lease versus one clause of the lease. But yeah, I mean, if I'm forced to analyze this situation based on just this paragraph, yeah, I think the tenant can go but the landlord could certainly provide or demand proof of the job loss. I don't think it's enough to simply say coronavirus hit, so I get out of my lease. I don't think that would suffice here. I think it would probably take a job loss. And that might be the case. And if that is, then that might suffice. But again, I'd want to see the whole lease before I'd say with any kind of authority or certainty that this gets the tenant out of the lease, because it's a very unusual lease term. So I'd want to look at everything else in the lease to see if I still believe that after reading the whole thing over.
And you can actually, our email and attorney form has a tool where you can upload a copy of a lease if you have it in PDF form.
Right. People scan it in, or, if forced to, they take a photo of it and send it over. And if I can't read it, I'll let you know. And then you can try to figure out a way to scan it. But yeah, we read leases. I look at a lease when I'm working on the hotline or taking emails. I probably read 3 or 4 leases a day. It's just one of the things we do.
All right. We have one more question here, so feel free. We have a little less than 10 minutes left for today's session, so feel free to send in your questions. Linda asks, are we potentially helping rich landlords? When a landlord receives relief in back payment of rent, can they be held to a needs-based status, meaning only those in need, not rich landlords get their tenants get helped?
And Eric, I think once again, I'll let you probably take the first stab at this one and add any thoughts I have.
Yeah, I mean, I'm not sure there's any type of legal precedent for that other than that's what we do for tenants when they're seeking emergency assistance to pay rent. So it's an interesting comment, and I'm not sure how legally that would work. There'd be some interesting hoops to jump through, probably, because of the different makeup and nature of how different landlords are organized, either individually or by corporation or whatnot. But I think it's a helpful comment, and I'm sure it's something you folks can try to advocate for among some of these local jurisdictions that are providing for some rent assistance programs.
Yeah, and I see what Linda's saying for sure. And I get the point that, hey, wait a second, why should we be padding, rich landlords' pockets? I will say this, that the governor's order is not banning evictions. The moratorium on evictions is not limited to low-income renters. There are, a sizable percentage of renters who are pretty well off by pretty much any standard that we might measure them by, but that rule applies to those tenants as well. So I think, Eric, you're right that emergency assistance is one of those places where we see some sort of means-based test. Most public assistance, whether it's through a social service provider or like a church, will ask for some evidence that somebody needs some help as well. But yeah, I get the point, and I guess I don't like the concept either of, giving a subsidy to wealthy landlords, but that's a complicated question, and try to figure out a way to answer it and still be fair to all the tenants and all the landlords is tricky to do. But I mean, it's talking to your legislator to figure out a way if there is one. We're more mechanics than car builders at this point right now. We're just trying to figure out what all the rules are that everybody has to play by to make sure that they're applied fairly versus building the rules.
We got a question or a comment. Washington County is not providing emergency assistance right now for past due rent because clients cannot be evicted. Is that legal?
Huh. I get the logic of that. I have not been hearing that from anywhere else. Have you, Eric?
Yeah, I think we did hear about this, and it may have been Washington County. I think we got a client or two call about it. I'm not sure if it was Washington or somewhere else, but
Okay.
yeah, I mean, I think the argument they're making is, well, it's not an emergency right now because you're not at immediate threat of being kicked out of your home, which is really sort of a backwards review of the situation, because you're just going to have a backlog of folks that as soon as the suspension lifts that are going to be coming to the county asking for the support. So
And they might be
you help
asking
them
for so
over
much at
time,
that
or
point
yeah, do
that
you
they'd
help them
be
over,
beyond the limits, right?
right? Do you help them over time, or do you wait until the big mess occurs? So I'm not sure if we can answer the question about if it's legal. I think rules around emergency assistance are tied to how the county commissioners have set it up, and there are some, I think, federal guidelines and state guidelines through DHS around how some of that works, which we're not experts in. There are public benefits attorneys at Legal Aid that might be able to answer that better.
Yeah, I don't know the answer from a, hey, is this legal or not perspective. Again, I'd start by looking at the federal legislation, which is where emergency assistance ultimately comes from. It's just administered by local agencies. This isn't what we're hearing on a universal level from counties around the state. And so anybody that decides to do something different than what's done by everybody else should be thinking, well, wait a second, are we just the smart ones that have figured out the loophole here, or are we the outliers? And if so, can we justify our position? But there are downsides for emergency assistance going this route, which we just talked about, is they're going to have a massive backlog once the evictions are fileable, and it's going to push people beyond the allowable limit to what they can actually provide support for. Plus, I mean, the whole concept behind emergency assistance is to help people find some solid footing. And right now, footing is about as uncertain as life has ever been in this country for almost all of us. And so taking away that one potential chance to help people find some solid ground seems like the wrong move to me. But, I don't work for Washington County, obviously.
And a comment that somebody has heard about this in several counties. So yeah, I mean, some of these counties are getting I think, CDBG COVID assistance, and there's some direction around how that's supposed to be used, but the county elected officials have some, I think, flexibility in decision making around how it gets used. So, people need other forms of support, but maintaining housing stability is pretty much a pretty high priority. So I'm not seeing any other questions, and I'm seeing that it is 2:30. So I think with that, we will call it a day and thank everybody again for participating. And we will potentially see you again next week. We will do another one of these next Wednesday at 1:30, and you'll get a follow-up email with a link to the recording for today and the recordings of previous seminars, as well as registration for the next one.
Thank you all.
Thank you.